Hi, I'm John Mayfield, the real estate tech guy with another Global Real Estate School podcast. Welcome to the podcast. My name is John Mayfield, the real estate tech guy, and thank you so much for joining. We are doing a live stream. We will be going over some questions for the real estate examination, and so I'm calling it a crash course for passing the national portion of the real estate exam. And we are live streaming on a various number of platforms, Twitter, LinkedIn. We're going live on LinkedIn as well. We're on a couple of Facebook pages, including my personal Facebook page. We are live on our YouTube channel and my Business Tech Guy YouTube channel. So I do have my chat window up, and you are supposed to be able to ask me questions from any of those platforms. So if you want to say hello or type in a chat, ask a question, you're welcome to do that. So we're going to get into the broadcast. I want to remind you, be sure and subscribe to my YouTube channel. I have another camera. I should have put that up, and I'm going to, just so we have that with us here. So if you'll give me just a moment to wake that little camera up. I think it is awake. Let me see. There we go. Just try to get all of my stuff here ready to roll. I should have had that camera up. We'll see if that camera comes up. Actually, it's not, so we will worry with it in just a little bit. In fact, I'm going to go to the question here, and I can maybe try to get that camera up and going. All right, so our first question, we're going to go through a bunch of questions today, and our first question is, which of the following interests are held by Bob Smith, who's granted a lifetime use of a property that will be transferred to Mary Davis, a third party, upon the death of the lifetime user? So again, which, and I'm going to fix something else right here. Just you go right ahead and take a look at this, but I just want to kind of fix this a little bit so it's more centered up for you. There we go. All right. Which of those do you think it is? Actually, we did this the other day, didn't we? And the answer is a life estate. So what you have to remember about a life estate is that it's used a lot for estate planning, but a lot of situations might arise where you want to provide a child a property, or you might, and again, I'm not an attorney, but I'm just trying to think of ways I've heard of this or seen this, but I may have a property and I could convey a life estate. Actually, I think I could actually convey a life estate to myself, and then I'm the life tenant. I'm also the grantor, and I'm the life tenant, but I could name my children as the remaindermen so that when I die, the property would go to my children. You could also have what's called a para terve, which means it's for the life of another person. So again, these are all kind of different types of ways for estate planning, but the key pieces of information you need to know is that, number one, who's the creator of the life estate? And that's the grantor. That's the person who signs the deed. That's who creates the life estate. And then whoever they name on the deed is the life tenant, or the owner or holder of the life estate. Okay? That life tenant has the right to keep that property, use it, sell it, do whatever they want to with it. But whenever they die, it then moves to the remainderman, or it reverts back to the original grantor. So if you were a child of mine and I conveyed a life estate to you, and I wanted you to have the farm while you were alive, but if something happened to you and you died, I wanted that to come back to me. That's a real basic example of a life estate. Remember, I'm the grantor. You are the life tenant, the owner of the life estate. You can do whatever you want to with the property, but when you die, it reverts back to me. Now, if you have a sibling and I wanted to name them as the remainderman, again, you're the life tenant, I'm the grantor. You have the life estate, but when you die, it would go on to the remainderman. So when we look at this question, and this is how they can really trip you up on these, which of the following interests are held by Bob Smith, who is granted a lifetime use of a property that will be transferred to Mary Davis, a third party, upon the death of the lifetime user? Well, Bob Smith has this lifetime use of the property. What's his interest, or what does he have? He has a life estate. And what does Mary have? Mary is the remainderman. All right. We did this question a couple of days ago, and we also did this one. Actually, I'm going to skip any math problems today because those are for another day. But we actually did this problem yesterday, I believe it was. How would you answer a client who asks you to compare, or comparing a physical life to economic life? How would you answer a client who asks you, compared to physical life, economic life is usually, well, is it the same? Is it longer, shorter, or could it be shorter or longer depending on the type of improvement? Now, remember what I told you is that economic life versus physical life. And I gave you the example of a barn or a home that's about to fall over and nobody's living in either one of them. Nobody's putting any equipment in the barn. There's no hay in there. I mean, you get close to it and there's some fear that comes over you because this thing could fall over at any moment. The house has floors falling through. The windows are broken out. But remember, what I said was there's still a physical life, isn't there? So when you look at this question, how would you answer a client who asks you, compared to physical life, economic life is usually, well, economic life's usually shorter, right? It's usually shorter because physically a structure could stand or still be standing, or still be, the walls, and it could have a partial roof, even though part of the roof is gone. Physically, it's still there, but economically, there is no economic benefit. So again, hopefully you understand the difference between physical life and economic life, and appraisers will use that, and you need to know that for the exam. Okay, our next question. Mike Smith is asking about when an executed sales contract may be assigned. Under which conditions would you suggest? What I went through a lot of these questions, and some of these were I read a lot of exam questions, and then I try to take the topic or the whole, just the main principle inside some of these questions, and then I just totally blow them up and rewrite them into a question format. And so I remember, and this question I saw was worded a lot differently, but there were a couple of things that were unique in this question that I thought kind of tripped me up. But think about this. Mike Smith is asking about when an executed sales contract may be assigned. Under which conditions would you suggest? Well, would it be unless the contract prohibits it? Only with the seller's permission? There is a clause in the contract that says you can assign a contract under no conditions or only if the contract provides for it. Could you assign the contract? There's a key word in this question that you need to be careful about, and it can trip you up. And the answer is, or the word that you have to be careful is the word executed. There are two definitions, and by the way, I hope this is okay since I'm doing a crash course to do a pitch for my digital flashcards I created, because I cover these words. And if trust me, if you go through my digital flashcards and you know those definitions, you'll pass the test, because you'll just know how to apply the terminology. That's the biggest part of this exam. So check out my digital flashcards at Global Real Estate School. They work in all 50 states. It's for the national content. But you would get this right if you had my digital flashcards. And that's what's cool about them. You download them to your phone, and then you can just sit here and go through them. And while you've got some downtime or at lunch or wherever, study for the test, and you'll do great. Global Real Estate School students, they are free for you. They are included with your tuition. They're under your additional references. You can download the PDF version, or you can download the little PowerPoint, which is what I like, and I have a video that shows you how to work those and so forth. But anyway, the key word here is executed. So in the digital flashcards, you have words, and there's this word right here, executed. See it? Executed means everything's completed. It's finalized. It's finished. Executory means it's lacking something. So if Mike Smith is asking about when an executed, a finished, it's done, there's nothing lacking, sales contract may be assigned, under which conditions would you suggest? Under no conditions. Remember, executed means it's finished, okay? That's a trick question. But it's a great question for you to understand how you have to read those questions very, very carefully, okay? So, again, going back to that, just so you can see it, under no conditions. Why? Because of that word right there, when an executed sales contract. So, got to read those questions very carefully. Cindy has a promise to perform in a contract. What is her promise to perform in the contract called? Wow, this is a tough one. Is it a personal contract? Is it a service contract? An option? Or is it consideration? Man, what a great way for me to push my digital flashcards. Because you just learn this stuff when you go through the flashcards. But if Cindy has a promise to perform in the contract, that is called consideration. Consideration. So Cindy has a promise to perform in a contract. What is her promise to perform in the contract called? It's called consideration. That's the consideration, is the promise to perform inside the contract. Larry is selling his home to Bob. Larry promises to sell, and Bob promises to buy. This is known as, is it mutual agreement, consideration, an option, or offer and acceptance? Which one of those do you think it is? I should have fixed up my OBS so that my picture could be on some of the PowerPoints, and then I could talk to you as we looked at the problem. I could do that very quickly, and I might try to fix that here. But the answer is, in this example, it is, go back over here so you can see it, it is consideration. So if Larry is selling his home to Bob, Larry promises to sell and Bob promises to buy. This is known as consideration. It's the money, the promises, or something of value. In fact, let me just see if I can add. And by the way, if you have any questions or you want to type in the chat, go right ahead, because I can answer those questions for you. So it doesn't matter what platform you're on. If you've got a question, put those in and we will answer those questions for you. All right, the next question. Larry is accused of taking advantage of Susie in the execution of a contract. What is Larry guilty of? Is it duress, stress, menace? I hope that's how you pronounce that. Or undue influence? Larry is accused of taking advantage of Susie in the execution of a contract. What is Larry guilty of? Well, I think Larry is guilty of undue influence. It's taking advantage of someone. Duress is forcing someone to do something, while menace is putting someone in danger, okay? So if Larry's accused of taking advantage of Susie in the execution of a contract, that would basically be undue influence. Duress, again, is forcing someone to do something. And menace is really when you put someone in danger. Good questions. I spent a lot of time working these up just for you, okay? So be sure and check those out. And if you have not subscribed to our YouTube channel, I want you to do so today. Please do that. We'd love to have you as a subscriber. Click on the bell and you'll be notified each and every time we go live, okay? So do be sure and do that. You can search for us at Global Real Estate School. You might be watching this on LinkedIn or Twitter, but go over to YouTube, search for our channel, and be sure and join us there. All right, the next question. We're going to keep rolling through here. Rebecca has a lease agreement in which she has the right to purchase the property before the end of the current year. What does Rebecca have? Well, is it an option lease, an option contract, a purchase option, or a lease option? Okay, I'm going to be honest with you. This question right here is why that real estate exam is so stinking difficult, okay? Because you look at these questions and you say, I mean, it could be a couple of those. I mean, you look at it and you go back to this question and you think to yourself, well, if Rebecca has a lease agreement in which she has the right to purchase the property before the end of the current year, what does Rebecca have? Well, she has an option lease, right? But she also has, is it an option contract? And the questions can be challenging. Well, in this example, Rebecca has a lease option. Okay, because if you read the question, Rebecca has a lease agreement in which she has the right to purchase the property before the end of the current year. What does Becca have? Well, she doesn't have an option lease. She doesn't have an option contract. Those would actually come first. She doesn't have a purchase option. Remember, when a lease is combined with an option contract, it's considered a lease option. I would take a good note of that and make sure that you have that. that's a good question there, and I want you to make sure that you're familiar with that. So, hey, don't forget, if you do have any questions for us, I'm just trying to look here. I have my chat window open, so you're welcome to give us a chat in any platform you're on. So it'd be cool if you're out there, say hi to me, and then I know that somebody's out there watching, okay? And I hope this is helping you out. So, all right, I have a good friend of mine over at Fort Leonard Wood. If you need to buy or sell real estate over in that area, you look for Antoine. He's a great guy. And Antoine, I used your name here as I wrote this question. Antoine is under a lease purchase contract as a buyer. Which of the following statements are true? Now, so he's under a lease purchase contract as a buyer. Is Antoine required to buy the property? Well, under a lease purchase, if you're under a lease purchase, they're trying to drag you into, is this an option? If you enter into a lease purchase, that's a contract, right? Is that the right answer? A. Well, John said what? I said, always be sure and read the question 2 or 3 times and all of the answers 2 or 3 times. So do not answer A just because you think that's the answer. You'll miss 3 or 4 questions doing that. Out of 100, you could even miss 5 or 6 questions. And we don't want to miss easy questions just because we didn't take the time to read it a couple of times. So A says, I'm just trying to fix this a little bit here. A says Antoine's required to buy the property. B says Antoine may buy the property if he so chooses. C, Antoine must first enter into a lease agreement with the owner before negotiating the purchase price. Well, he's already under a lease. So, we could toss C out totally, couldn't we? And D, Antoine is required to make a down payment of earnest money to enter into a lease purchase. Well, first of all, and they love to throw that into the exam, earnest money is not always required. If all parties agree that you can have a 0 deposit or 0 earnest money, you still can have a contract, okay? They love the question. Usually see this on the state side of the exam, but they love the question. Someone wants to put up a diamond ring or a boat or a cow as earnest money. Is that okay? And the answer is always, well, if everybody agrees to it, yeah. If you want to buy my property and you say, here's my diamond ring as collateral, and I look at it and, examine it, and my wife says, hey, I love that ring, and, I'll let them put that up as earnest money. If you don't go through with the transaction, you lose your diamond ring, right? So going back to this question, C and D we can totally throw out. And so let's read the question again. Antoine is under a lease purchase contract as a buyer. Which of the following statements are true? Well, if you're under a lease purchase contract, A says Antoine is required to buy the property. B says Antoine may buy the property if he so chooses. Well, I think if you're under a lease contract, I think you're required to buy the property. It's a binding contract. And so the answer is A. Now, here's what I want you to take away from this. I definitely want you to remind yourself that John told me I must read all the questions a couple of times, okay? So be sure and read your questions a couple of times. I want you to do that. Secondly, I want you to understand that earnest money's not a big deal. I mean, it is, but for the exam, If everybody agrees there can be a promissory note as earnest money, that's fine. In the real world, you want to get earnest money. It helps with negotiating. It's a big deal. But for the exam, as long as everybody agrees, you can use whatever you want to as earnest money, and you can even have zero for earnest money. You could even have a promissory note, as I mentioned. But on this question, if they're under a lease purchase contract as a buyer, they're required to buy the property. It's a binding contract, okay? All right. Judy is an experienced agent and would like to begin contacting her past clients for relationship building purposes. According to the do not call rules, Judy may contact clients never, indefinitely, 18 months after a sales transaction, or within the first 18 months after a sales transaction. This is a good question. I'd be taking notes if you're going to take your exam or you're trying to pass a test, because this is on the do not call rules. And if Judy is an experienced agent and she would like to begin contacting her past clients, and the key here is for relationship building purposes. See that? For relationship building purposes. According to the do not call rules, Judy may contact her clients. Remember, we're reading them 2-3 times. Never, indefinitely, 18 months after a sales transaction, or within the first 18 months after a sales transaction. Well, the answer is indefinitely, because according to the do not call rules, calling past clients for, and there's those key words, relationship building purposes, following up, information, etc., may be done for an indefinite period of time. So, Judy, and some of my friends may be watching who are licensed real estate agents. Now you know, for relationship building purposes, you have the right to call indefinitely according to the do not call list. And this is, again, is to your past clients, okay? Your past clients, if it's for relationship building purposes, indefinitely. All right. A couple of you got that right. Good job. Which of the following statements about radon are incorrect? Which of the following statements about radon are incorrect? It is colorless. It is odorless. Radon is actually liquid released into the soil. It is created during the natural decay of radioactive uranium. A radon question. Some of you are saying, do we need to know that as real estate agents? Well, radon's becoming a big deal today. And for the real estate exam, yeah, you need to know it. You never want to give expert advice to clients or customers, but you may need to you need to understand a little bit about radon gas. And what's interesting is it is colorless and it is odorless. I know that's correct. It says, which of the following statements about radon are incorrect? Well, C and D kind of stump me. Is it actually liquid released into the soil, or is it created during the natural decay of radioactive uranium? Well, the correct answer, which is incorrect, right? That's kind of challenging, isn't it? Because it wants to know which one of these statements is incorrect. And the incorrect statement is radon is actually liquid released into the soil. No, radon is a radioactive gas that's in the soil. You know, as a real estate professional, you definitely really want to have your customers and your clients client, especially when you're working as a buyer's agency, as a buyer's agent, because you have those fiduciary obligations. Remember, care, obedience, accounting, loyalty, disclosure. And so in this situation here, you definitely should have the inspector do a radon gas test. That's normally not included in a home inspection. Just have your buyer ask the inspector, is that included? Might be an extra $100 charge, and they normally have to leave a unit there for a couple, 3 days to run the test. But and it is curable. They can fix radon. Normally have to, I don't know the procedures, but there's normally some type of a vent or a machine or whatever they put inside that pulls the radon gas out of the basement and the lower level or underneath the house where they normally find that, because, as it mentions there, it's a radioactive gas that's actually in the soil. So always good to have your clients get a radon test. But now you know on the exam, and this is a good way to study this question, radon, it's colorless, it's odorless, and it's from the natural decay of radioactive uranium. So the incorrect answer is it's not liquid released into the soil. It's actually radioactive gas that's in the soil. Just going to see if we have anybody that's in the chat room talking to us, but nobody's there, and that's okay. If you have a question, just feel free to pop one in there. We are going to keep on with our crash course exam. Not going to go through all the questions, but I'm going to go through a big chunk of these for you. My apologies, I just hit the microphone. Mary has a house listed and a recent hailstorm impacted the property. Mary's clients informed her of the damage. What is the next step Mary should recommend? Well, should Mary have the sellers call their insurance agent and file a claim? Should she allow the buyer to find out through their inspection? It would depend if the inspection had been completed or not, or inform the buyer's agent and buyer and discuss how to proceed. Again, a very good classic question on how they like to give you two that look really similar and two that you can throw out. So if we go back and read this a second time, we could throw two out very quickly. Mary has a house listed and a recent hailstorm impacted the property. Mary's clients informed her of the damage. What is the next step Mary should recommend? Now, ask yourself, who's Mary? Mary's the listing agent, right? So A says, have the sellers call their insurance agent and file a claim. That sounds pretty good, doesn't it? Let's hang on to that one. B says, allow the buyer to find out through their inspection. Now, we can throw that one out. We don't want that to be there. C says, it would depend if the inspection had been completed or not. We could throw that one out. But D says, inform the buyer's agent and buyer and discuss how to proceed. So when I look at this question, I've really narrowed it down to A and D. B and C, I think we could throw out. So let's go back and read it a third time, because it never hurts. Mary has a house listed and a recent hailstorm impacted the property. Mary's clients informed her of the damage. What is the next step Mary should recommend? Well, Mary's the listing agent. Her sellers have called her up, said, hey, the recent hailstorm that went through, we've had some damage done to our roof or whatever. What should Mary as the listing agent do? Well, we said we were going to hang on to A, have the sellers call their insurance agent and file a claim. But we also said D as in David looked pretty good. Inform the buyer's agent and buyer and discuss how to proceed. Well, if you looked at these two, which of those really, for Mary as the listing agent and with someone who has a contract on the property, which one do you think would be probably of utmost priority from Mary's point of view? Well, I think it would have to be D, and that's the answer. Inform the buyer's agent and buyer and discuss how to proceed. Now, you're going to get down a lot of times to two possible answers. This is a great question where two answers look pretty good. But you have to ask yourself, and going back to this, I have to say, have the sellers call their insurance agent and file a claim. Well, yeah, that makes sense. But if there's a buyer's agent and a buyer involved in the property, even though they don't give us that information in the stem of the question, if that's the situation, that answer's a better answer. Because if you've got a contract with a buyer's agent and a buyer agent has their clients, this damage has now become what? It's become a material defect. And a material defect always has to be disclosed by you, the agent. So anytime you get information that now affects the property because of value or a problem like this, it's a material defect. You have to disclose that to the buyer or the buyer's agent if there's another company involved, a buyer's agent. And so the correct answer in this case would be inform the buyer's agent and buyer and discuss how to proceed, because now you've come in contact with a material defect and your first order of business is, hey, I've got to tell the buyer's agent and make sure their buyer is notified and find out how they want to proceed. Okay? They may, I don't know, he could be a roofer and he may say, yeah, have him call the insurance agent, but I want to fix the roof myself. Who knows? So D is the best answer. So just always, 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 if you narrow down to those two, try to ask yourself, of the two, which one makes the best sense, okay? And you could have sat there and said, well, gosh, I mean, they need to call their insurance agent and file a claim really quick. Yes, that's true, but you as a seller's agent have an obligation to disclose all material defects in the property. Okay? So, correct answer for this situation is D, as in Donald. Tom has Ginny's home listed. All of the following statements concerning Tom's responsibility as an agent to Ginny under a listing agreement are true, except, well, Tom should be able to account for all of Ginny's monies entrusted to him. That's true. I think. Tom must not reveal any confidential information about Ginny's financial condition. Is that a true statement? Tom must not reveal any confidential. That could be true, right? You're not supposed to reveal confidential information, but it's worded. We're going to read this a couple times. C, Tom must disclose all known material facts, even if they have a negative effect on Ginny. True. D, Tom is responsible for any losses incurred by Ginny. Read the questions how many times? 2 to 3. 2 to 3 times. So let's read it another time. Tom has Ginny's home listed. All of the following statements concerning Tom's responsibility as an agent to Ginnie under a listing agreement are true, except Tom should be able to account for all of Ginnie's money entrusted to him. True. Tom must not reveal any confidential information about Ginnie's financial condition. True. It's confidential information, or finances. You don't reveal it. Tom must disclose all known material facts. There was just a hailstorm. What do we do? Even if it has a negative effect on Ginnie. True. Is Tom responsible for any losses incurred by Ginnie? That is a false statement. Tom would only be responsible for the losses he caused, okay? Not the losses incurred by Ginnie. So D is an incorrect statement. It is not true, but all of the other statements are true. All right, we're on to another question here. I'm having fun. I hope you're having fun. You may be watching this at whenever and wherever, and maybe going to take your real estate exam tomorrow. And so you're saying, shut up, John, just give me the questions. That's what we're going to do. So here we go. I have to remind myself that. Jerry had a mortgage. Jerry paid his mortgage in full. It is now said in legal terminology to be, holy cow, amortized, fully amortized, executory, or satisfied. If you have those digital flashcards I was talking about from Global Real Estate School that are on your phone that you can go out and download and review them at any time, you'll get this right. And by the way, they're not very expensive at all. I mean, they're $35, and you probably spend that much on a couple of cappuccinos at Starbucks or your favorite coffee shop. Global Real Estate School students, they're included, so you need to download those and use those. But in this example, I think if Jerry had a mortgage and he paid it in full, it is now in legal terminology to be satisfied. That's the answer, satisfied. So put that in your memory bank and remember that. Which of the following activities does Ginnie Mae not purchase loans? Urban renewal projects, new subdivisions, senior citizen housing, or housing for experimental purposes. Which of the following activities does Ginnie Mae not purchase loans? Well, the correct answer is new subdivisions. They do not purchase loans in new subdivisions, but they do purchase urban renewal projects, senior citizen housing, and experimental housing purposes. I'm going to do math on another day, so we'll come back and do that. This one is another math problem. We'll do that on another day. Peter had a money judgment issued by the local court. When recorded, this money judgment always becomes a what? Is it an involuntary lien, a voluntary lien, an equitable lien, or a court lien? Peter had a money judgment issued by the local court. When recorded, the money judgment always becomes an involuntary lien, voluntary lien, equitable lien, or a court lien. Well, I think it's an involuntary lien, and it is, as I click my mouse, because if it was issued by the court, it's involuntary, right? Here's what you need to remember about these liens that are voluntary or involuntary. If you go out and get a mortgage on your home, that's a voluntary action, right? You got a mortgage loan on your home, voluntary lien. if the court issued a lien against you because you didn't, you failed to do something or something happened in this case, well, you didn't like voluntarily go to the court and say, hey, put this a lien against me. No, the court did that. And because the court did it, it's called an involuntary lien, okay? All right. I think I'm going to take a look here real quick because I'm pretty excited that I believe we just received our approval for our Oklahoma continuing education courses. We did. So that's exciting. So we are now fully approved for continuing education in Oklahoma. So it was cool to get that little piece of information during the... By the way, check us out at globalrealestateschool.com. If you're having trouble passing the real estate test, I also have a program called My Real Estate Exam Coach. If you go out and purchase that, you'll get an immediate download link to the site that has all of the information, a lot of great information there that you will see on the test. It's broken out. There are videos, lots of really cool information. So we've got the digital flashcards. We have the practice exams that are in the My Real Estate Exam Coach. So check those out. Would love for you to visit us at Global Real Estate School and send other students to us as well. And don't forget, every Thursday from 3 o'clock to about 4 o'clock, we're going to wrap this up here in a few minutes. I'll be doing some live streaming. We're going to go over questions like this. We're going to go over math, just do a lot of different things. So again, be sure and subscribe to us on YouTube. Check that out. We'd love to have you as a subscriber, and click that bell. When you click that, you'll be notified each and every time we go live. So, all right, we're going to go back to the next question here. Mr. Orzo had an easement appurtenant to real property owned by Peggy. This easement could be terminated by all of the following except, well, could it be terminated by a merger of both the servient and dominant parties? Yeah, I mean, that's one of the things that terminates an easement, okay? So I think A is true. And again, we're looking for, all of these could be terminated except for one of them. Prescription by Peggy. So Mr. Orzo had an easement appurtenant to real property that's owned by Peggy. So in this example, Peggy would be the servient estate, right? And Mr. Orzo would be the dominant estate. Easement appurtenant is just the type of easement it is. It's a roadway easement. An easement in gross is a utility easement. So if Mr. Orzo had this easement appurtenant, which is just, let's just say, a road to go across property that's owned by Peggy, how could that easement be terminated? Well, prescription by Peggy, I don't know. That's weird, isn't it? Revocation by Peggy. Well, could Peggy revoke the easement? I don't know. Release by Mr. Orzo. Well, if he had the easement appurtenant and he released it, that's a true statement. So again, we're getting down to another question that has two answers that we're just beating our head against the wall, and we're like, I don't know. What could it be? So we read it again. Mr. Orzo had an easement appurtenant to real property owned by Peggy. We know, and you know what I would probably do is draw this out on my, I think when I was able to take the test for the one state that I was getting our school approved in, because I had to take it as an instructor, I kind of drew out a parcel of property, and I drew A, B, landowner A, landowner B, and I had the easement. So I've got Mr. Orzo has the easement and he owns the property in the back. He's the dominant estate. Peggy would be written on landowner A in the front. She would be the servient because she's serving Mr. Orzo. And so prescription by Peggy or revocation by Peggy. And so the answer is revocation by Peggy, because as I read this through, Peggy can't revoke the easement. The easement's in place. And remember, easements run with the land. So Peggy could never revoke that easement because she's stuck with it. Now, when it says prescription by Peggy, they're probably talking about the fact that she's built a wall, or she's like covered up the driveway and she's planted flowers and it sits there for 10 years. And then she goes to court and says, hey, wait a minute, he's never used it, or I built a house there. And so, you know, that whatever that is. But when you look at the question, all of those are true except, well, I know that Peggy cannot revoke the easement because she's the servient estate and she's stuck with the easement unless a merger of the parties, the easement no longer exists, a release by Mr. Orzo, who owns the easement. He could release it and say, I don't want it anymore because I can get in this other way. So there's all of those ways that you can get rid of an easement. But revocation, and that's just revoking the easement, Peggy can't do that. I mean, once it's there, it's there. And remember, easements run with the land, so that easement's going to be in place for a long time. Okay? All right. Until one of those items no longer exists. So let's go to the next question. If Tom holds a fee simple estate in property, which of the following will result in Tom being left with a non-freehold estate? If Tom holds a fee simple estate in property, so he owns property, fee simple, highest type of ownership you can have, which of the following will result in Tom being left with a non-freehold estate? Well, A, if Tom assigns a right-of-way to the state highway department. B, if Tom decides to lease the land to Jerry on a long-term lease. C, if Tom sells the mineral, oil, and gas rights to someone else. Or D, none of the above. Well, kind of a trick question. If you own a fee simple estate, you're not going to be left with a non-freehold estate because you own it, right? So the answer's none of the above. Don't let those others trip you up. Now, I only read that one time because I'm trying to be respectful of your time, but always read the questions a couple of times, okay? Anne was curious about the validity of a deed. Her question to you is, the absence of which of the following would invalidate a deed? So here's Anne. She's curious about the validity of a deed. Maybe she has a deed for some reason, and she's like, is this really valid? So she asks you, hey, the absence of which of the following would invalidate a deed? The signature of the grantee, the delivery, recording, or the legal capacity of the grantee? Which of those would invalidate a deed? Kind of an interesting question, isn't it? I would tell you if you had my digital flashcards, you'd probably, or my real estate exam coach, you'd probably have access and you would be able to answer this really quick, and you would probably immediately say, John, delivery. Which of the following would invalidate a deed? The answer is that delivery would invalidate it. The signature of the grantee wouldn't, just because the signature, that's not going to invalidate a deed. Recording's not necessary, so that's not going to invalidate a deed. The capacity of the grantee, you can transfer a property to children. That happens a lot. But remember, for a deed to be valid, you need what? You need delivery, and you need acceptance of the deed. So if there was no delivery, I could have a deed drawn up, but if I never, and sign it and go through all of that process, but if I never deliver it to you, you never know about it, right? So that would invalidate a deed. And sometimes, they might have that question where they stick the deed in a drawer and no one ever finds it. Well, it was never delivered. So that's kind of why that specific answer would be there. And there's a question about a contract on throwing in a desk drawer, and I always wish I could find out more about that question. But anyway, at a recent sales meeting, you'll overhear several agents discussing a title plant. What are the agents talking about? Are they talking about title policy of insurance, a spot survey, a survey registered with the title insurance policy, or a collection of real estate records? Well, it's kind of a weird question, but a title plant is a title company, and it's a collection of real estate records. So if you see that question, you know how to answer it now, don't you? I think we have time for one more. If Alex and Dan, I used my daughter and son-in-law's names, they're my team members here. If they accepted an offer on their home, but changed only the date of possession and initialed that change, the buyer would be bound by the contract and unable to withdraw their offer. The offer would become a counteroffer, and if the buyer did not accept, she could lose her deposit. It would become a counteroffer subject to the acceptance by the buyer, or none of the above. Hey, they love this question. I'm sure you will see some facet of this specific question on the exam. And if you reread that again, we've got 1 minute left here. If Alex and Dan accept an offer on their home but changed only the date of possession and initialed that change. If you change anything on the contract, it now becomes a counteroffer. So A is false because we know it's a counteroffer. The buyer's not going to be bound to that. The offer would become a counteroffer, and if the buyer did not accept, she could lose her deposit. Well, if it's a counteroffer, the buyer can do whatever they want to with it. So C, it would become a counteroffer subject to the acceptance by the buyer. And that's the answer. D's none of the above. So don't look at that. So there you go. That gives you your answers and questions for this exam. Thanks so much for watching. Check us out at Global Real Estate School. And as always, go out and make it a great day. Thank you for listening to the podcast for Global Real Estate School. I'm John Mayfield, the Real Estate Tech Guy. Go out and make it a great day.